Welcome back to this third segment of Land Law Freehold Covenants. In the last segment, we did consider how another party, whether in being at the time or a successor in title, can get the benefit of a freehold covenant. So in order to successfully enforce a covenant, the assignee must show that the benefit of the covenant has run to himself from the covenantee, and he must demonstrate that the burden of the covenants has passed to him, the assignee of the servient land, from the covenantor. Now the assignee, of course, is the person who will no doubt have purchased Blackacre from the original owner. Because if you go back to my example at the beginning, let's assume that one person owns Blackacre and Whiteacre, and he sells off Whiteacre, but then he subsequently sells Blackacre. If it is that he sells Blackacre, then the question is, does the benefit of the covenant pass? Meaning, if, for example, in my original example, I said to you, what if the person buying Whiteacre, the covenant says that he cannot build a high-rise block of flats? Well, what happens when the original covenantee, which is the owner of Whiteacre, the owner of Blackacre, what happens when the original covenantee sells Blackacre? Is it a situation where the new owner of Blackacre can take the benefit? So, in still considering how one of the original parties to the covenant can, of course, get the benefit, we've looked at it from a personal context so far. So we've looked at it from section 56, where it considered looking at persons who were in being at the time the covenant was made. Equally, we've looked at the contract rights of third parties, and both have shown that the benefit can, of course, pass personally. There is, of course, passing by assignment, and this is where the original party to the covenant can assign the benefit of the covenant to a purchaser. Now, assignment means passing on to the next owner of the land. Now, assignment is possible in both common law and equity. And in common law, we will see that it is the benefit which can be assigned. Equally, we'll see in equity that it is the benefit that can be assigned. So now we have three possible ways of the benefit passing personally. The one is section 56 as a successor in title under the contract rights of third parties and by being assigned. Let's start with looking at a legal assignment. Well, under a legal assignment, this is under section 136 of the Law of Property Act 1925. Of course, in equity there can be an assignment as well. The benefit of the covenant can be assigned to the next person who buys the benefited land, and the conditions for a legal assignment are as follows. It must be in writing. Written notice of the assignment must be given to the original covenantor, whereas an assignment in equity, the benefit of the covenant can be assigned to the next person, and the conditions there that need to be met are set out in Miles and Easter. And in Miles and Easter, there are 4 requirements. And these are that the land benefited by the covenant must be identifiable using extrinsic or outside evidence if necessary. Secondly, the covenant must have been taken for the benefit of the land owned by the covenantee at the date of the covenant, and the land that benefited from the covenant must be retained in whole or in part by the person now claiming the benefit of the covenant, and the land that the benefit from the covenant must still be capable of benefiting from the covenant. And of course, the assignment must be at the same time as the transfer or sale of the land to which it relates. So what we see is that in equity, it is not strict about the writing requirement as the common law is, but certainly it shows that the assignment must occur at the same time as the transfer, as long as all the other three requirements are met as set out in Miles and Easter. Okay, to this point, we have looked at the parties to the original contracts passing on the benefit. And again, by way of recap, Section 56, contract rights of third parties and assignment. But do we need the parties to the original covenant in order to pass on the benefit? Well, why not look at the land itself? Can the benefit of the covenant stay with the land? So it doesn't matter if you are the original covenantor or the original covenantee. Can it be that a covenant was made in respect of this land and I take the benefit by virtue of that? Well, let's look at what the situation is. Well, instead of looking at the people, consider whether the benefit of the covenant stays with the land regardless of who owns it, and whether the burden of the covenant stays with the land again regardless of who owns it. So if we look at stamping the original covenant on both pieces of land so that the benefit becomes attached to it, or a party of the land that was originally benefited and the burden becomes attached to it, or a part of it, i.e. the land that was originally burdened, then of course it will run with the land, as it were. How can you get the benefit in that regard? Well, you can get it, we will consider it rather at common law, and we will also consider it in equity. That is, how do you get the benefit? You can get it at common law or in equity. Well, if we look at the benefit at common law, in the case of P&A Swift Investments and Combined English Stores PLC in 1989, Lord Oliver says, if there are 4 conditions satisfied, then you can get the benefit running with the land at common law. And they are these: that the covenant must touch and concern the land, that there must have been an intention that the benefit of the covenant should run with the land. Also, that the covenantee must have a legal estate in the dominant land, and the new owner must take a legal estate in the land. So if we considered each of these, the first is that the covenant must touch and concern the land. Well, the most helpful explanation of the phrase is found in the case of P&A Swift Investments itself, and it says, the questions you must ask are these. 1, whether the covenant ceases to be of benefit if it does not pass to the assignee. And 2, whether the covenant affects the nature and quality or mode of user or value of the land of the reversionary. The covenant must not be expressed to be personal. So you can't stop somebody, for example, doing something that is of a personal nature, because that will not allow it to pass, of course. The second thing is that it must have been intended that the benefit of the covenant was to run with the land. Now, the covenant touching and concern the land is not sufficient to show that the covenant runs with the land. It must also be shown that the original parties intended that the covenants would run with the land. So what you want to do is look to whether there is some sort of expressed or implied situation to show that the benefit was clearly intended to be for a long period of time. But in the absence of that, because how can you know what person's intentions are later on? Well, to make this easier, the Lord actually steps in, and Section 78 of the Law of Property Act provides that the covenant is deemed to run with the land unless the deed expressly provides otherwise. Now, the original covenantee must have held a legal estate in the land. That's more or less pretty self-explanatory. And the successor himself must also have acquired a legal estate in the land. Now, remember, we're dealing with the common law, so the common law is going to be very strict on that. The case, of course, to cite is Smith and Snipes Hall Farm Limited, where it was held that the benefit of the covenants would pass to anyone acquiring any legal estate in the land. Well, what if you cannot get the benefit at common law because you do not meet the requirements? Well, let's consider if equity will assist you. And the running of the benefit in equity is something that you have to consider, whereas I say you can't get in the common law. In equity, the benefit of a covenant may pass to the covenantee's successor in title if two conditions are met. It must be shown that the covenant touches and concerns the land of the covenantee, which is the same principle that was seen in relation to the running of the benefit at the common law. And the second is that the benefit of the covenant must have passed to the covenantee's successor either by annexation or a building scheme. So you see that it is slightly different when we start looking at whether or not equity will allow the benefit. Well, it says that it must touch and concern the land, and secondly, an either-or situation. Is there annexation or is there a building scheme? Well, let's look at annexation. The wording of the original covenant must show an intention that the benefit was to run with the land into whoever's hands the land would pass. Now, the benefit passing by proof of annexation will be proof that a covenant has fastened itself to the dominant land. If a covenant can be shown to have been annexed to the parcel of land, it will not require further annexation on a future sale of the dominant land. Now, a covenant is annexed to a piece of land. For it to be annexed to a piece of land, it may be evidenced in one of three ways. It can be express, which is pretty self-explanatory. It can be implied, again, based on what we know about implication at law, that is not too difficult to work out. And it may also be annexed by statute. Well, as it relates to statutory annexation, Section 78 says that a covenant relating to any land of the covenantee shall be deemed to be made with the covenantee and his successors in title, and the persons deriving title under him or them, and shall have effect as if such successors and other persons were expressed. So basically, what Section 78 allows is that the statute will step in and allow annexation if it appears that the party intended that it should be so annexed. And the case, of course, is Federated Homes and Mill Lodge in 1980. And it said that Section 78 automatically annexes the benefit of the covenant to the dominant land. Now, what about a building scheme? This is an interesting one, because where a building scheme exists, both the benefit and the burden of the covenant will pass with the land. This normally arises in respect of housing estates where a builder has imposed restrictions on the purchaser of each plot of land. The intention is that once all the plots have been sold, each purchaser and that purchaser's successor in title will be able to enforce the restrictions directly against each other. So what you get is a purchaser or his successor, anyone who's bought a lot of land or a plot of land in that subdivision will be able to directly enforce it against another purchaser or his successor in title. The requirements need to be established, the requirements which need to establish a building scheme were first set out in the case of Elliston and Reacher, which is a 1908 case, and it was based on the notion of mutual enforceability. Now, there are 6 requirements for the benefit to pass under a building scheme, and they are these. The plaintiff and the defendant must have derived their title from a common vendor, and that, of course, fits in with the whole building scheme idea, because this is where you get a developer, for example, building, say, a dozen houses, and then he says, for example, no one within the development should build a 2-story building. Let's assume it is a development with all bungalows, so it's 1-story houses. Well, the plaintiff and the defendant must have gotten their title from that one vendor. Also, before selling, the common vendor must have laid out the estate in plots. The common vendor must also have intended that the restrictions were for the benefit of all the plots. And the purchasers from the common vendor must have purchased on the understanding that the covenants were to be enforceable by every other purchaser. Also, the area to which the scheme relates must be clearly defined. Now, suppose there is a requirement missing. Could that be detrimental? Well, the case of Redolphin's conveyance in 1970, although it failed the Ellison and Reacher test because there was no common vendor, and prior to the sale the individual estate plots had not been laid out, Justice Stamp in the case nevertheless held that there was a valid scheme of development in existence. Also, in the Jamaican case of Jamaica Mutual Life and Hillsborough, the emphasis was placed on the fact that each person understood when he bought his plot that the covenants were mutually enforceable. So, equity will allow the benefit of the covenants imposed on the other plots to run automatically to all the successors of the original purchasers without the need for annexation. Notwithstanding, you can get a benefit in order for the covenant to be effective. The person seeking to enforce it must not only get the benefit, but show that the person against whom is seeking to enforce has the burden. Because even if you can show that you get the benefit, but you can't show that you get, or rather that the other party has the burden, then unfortunately it will be ineffective. We are now going to pause for a brief moment, and when we come back, we will see how the burden is passed and how once the benefit and the burden meet, then it will become a fully fledged right.